Okay, let's officially get started. Welcome, everybody. So excited to have you in class today. Today's class is one of our favorites. We're really taking a deep dive at looking at the 14th Amendment from its writing in 1868 all the way to modern cases, and we'll end probably around Obergefell in 2015. So we're going to fly through some American history, but really look at what is written in the words of the 14th Amendment and how people and the case law have defined it over time. So my name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and I'm here to help with any questions you have or any clarity that you need. So make sure you put those questions or, hey, go a little further on that idea in the chat or the Q&A. And lucky enough, I'm not alone in doing this work. I'm with Tom Donnelly. He's one of our top scholars at the National Constitution Center, and he's an expert on the 14th Amendment. So we're really excited, Tom, for this class. Want to say hi to everybody or any kind of big idea to start with before we get into this?
Sure. Hi, everyone. And yes, we're going to learn about America's second founding today. So it's an exciting topic.
So what a great place to start. Let's start there. What is the second founding? Number one, what is the second founding? Number two, what amendments were added to the Constitution to make it its second founding? And then kind of looking through what was this time period happening and what was the reasoning behind it as well. And then we'll dive into the words of the 14th Amendment and start parsing them out as well.
Yeah, so we're talking about the Reconstruction period here, Kerry. And so it's right after the Civil War. And so it's the Republican Party in power, the party of Lincoln, the party of Union, the party that won the Civil War. And so we're asking really, really big questions. We're saying, what have we learned from American history to this point? What have we learned from the Civil War that we just fought and so many people died from? What do we learn from emancipation, this push away from slavery towards freedom? And what do we owe African Americans? How do we make them equal citizens in the United States? And so here, these are the big questions. And so scholars argue that in many ways, when you look at this period, it's a new founding of America. Much like the first founding with the Constitution, we have a second founding here with a series of three transformational amendments: the 13th Amendment, the 14th Amendment, and the 15th Amendment. The 13th Amendment was ratified in 1865, so that's the same year the Civil War ends, and it abolishes slavery. The 14th Amendment then goes further and it writes the promise of freedom and equality into the Constitution. We'll talk more about that for the rest of this lesson. But then finally, and that's in 1868, that's ratified. And then finally with the 15th Amendment, it's ratified in 1870. And what that says is that we promise to ban racial discrimination in voting. And so altogether, all three amendments, the last big thing you see in each of them is they each expand the powers of the national government. And so one of the big lessons that the Republicans pull from the American experience to this point is, at the founding, we were really afraid of the national government abusing our rights, liberties, et cetera. But what we've learned from American history to this point is that states can abuse our rights too. And so we need national freedom, national equality.
Awesome. And that leads us perfectly into the words of the 14th Amendment. And as we go through, and you're going to see so many colors that I chose to highlight different words, but this amendment, this is just section 1, and there's 5 sections of it. But even in section 1, it's hard not to highlight the entire thing and say how much power are in these words. And as we go through this, what were the goals of these words? What were the freedoms and rights that the writers were trying to put into this amendment to say, we're going to put this on paper. The country is changing, and we need to make sure the Constitution is changed as well. So break it up and kind of walk us through what they mean and why they're in there.
Absolutely. So we're going to focus mostly here on section 1, but Curry's right. The 14th Amendment's really, really long. There's 5 sections. It's almost like a constitution unto itself. It feels that way sometimes because it's so long, and the ideas are so big and important. We're going to highlight 4 of them, and we'll sort of walk through this text of section 1 and sort of flag these different ideas. So the first one is birthright citizenship. And that's that first sentence, the citizenship clause. It reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And so here, what this language is saying is, 1, Supreme Court, you were wrong in Dred Scott. You were wrong in that decision before the Civil War. African Americans can be United States citizens. They do have rights, which the white man is bound to respect. And if you're born on American soil, you're a United States citizen. So that's birthright citizenship. That's that first sentence. Okay, the next big idea is freedom. And that's the beginning of the next sentence you see there. It says, no state. So again, remember, what we're concerned here now is about state abuses. The founding was all about limiting national government. Here we're beginning to limit the powers of the states. And so here the language is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. And this is all about national freedom, freedom that's going to apply to state abuses everywhere. The big idea here is that, remember, the Bill of Rights, when it was put in the Constitution at the beginning, only applied to the national government. Since the founding, we learned that states can abuse our rights too, and the 14th Amendment extended really important rights, like many of those in the Bill of Rights, like free speech and religious liberty, to abuses by the states. So that's birthright citizenship, freedom. The third idea is equality. And here the thing to remember is that the original Constitution was silent on the principle of equality. And what this amendment does here with that language, nor deny to any person within its jurisdiction the equal protection of the laws, is that it writes the Declaration of Independence's promise that all men and eventually all women are created equal into the Constitution. So that's birthright citizenship, freedom, equality. The last big idea is that we are going to expand the powers of the national government to protect civil rights. And so this is Section 5 of the 14th Amendment. And this is just an idea, the idea being here that these are the first sets of amendments that are expanding the powers of the national government. The original Constitution was all about limiting those powers. Here, we're saying that the government now has power to, the national government has power to enforce all of the protections in the 14th Amendment. Now, don't hear me as saying, now the national government is all powerful. Not at all, not at all. And we continue to debate to this very day how much power goes to the national government, how much power goes to the states. But what the Reconstruction generation was saying here is that the national government, for us to truly realize the promise of our nation's founding, of the Declaration, we need the national government to have more power to attack abuses by the states. And here's the key language: the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And so I'll pause there on the four big ideas.
I think that's awesome. Just one kind of, I know this is the advanced class, so I can kind of like pick apart these words a little. Is there a reason? So one of our teachers earlier asked, like, is life, liberty, and property the first time we really see those words of the Declaration in the Constitution, or is this kind of a second wave of that? But is there a reason, and this is why I have it in orange, that they use the word deprive any person instead of any citizen? So did they choose that on purpose? Was that just, no, not really, or was it's unclear?
I'll take the first question first. I mean, one thing to note about the language you're seeing in the 14th Amendment is, as we see with many amendments, we see the framers borrowing language from that's known to the American people and to their leaders. And so, certainly with nor state, any state deprive any person of life, liberty, property without due process of law, that parallels what we see in the Fifth Amendment. So it's in the Bill of Rights. But here what we want to do is we want to make sure, we want to be extra clear that that protection is going to apply to the states, not just to the national government. So that's where we see the due process clause there. I mean, the inclusion of any person really was an expression of how fundamental due process of law and equal protection was to certain members of the Reconstruction generation. The idea that we're not just going to give this stuff to American citizens. If you're here on our soil, we're going to honor these fundamental things like fairness, which we get from due process of law, and equality, that you're going to have equal protection of the laws. And so, I think it was just it was intended to be, expansive.
Yeah, no, and I think that's really interesting, because when we look at these words, you're right. Sometimes to make big changes, they will use words that are familiar. And we see that over and over again when we talk about constitutions and pieces of the Constitution. Where did they get the idea from? But in this area, they're saying any person. So we're making this real broad statement here, and that's on purpose. Okay, now kind of diving into this, when we think of those four big ideas or four features of the 14th Amendment, you just walked us through in Section 1 and Section 5. And everybody read the whole thing. It's long, but it's great. Birthright citizenship, protection of equality, protection of freedom, and Congress now is given more power. Let's begin with birthright citizenship and walk a little bit through that timeline. Why is it in there? It are the framers of the 14th Amendment trying to overturn right or wrong and overturn things? Why is it in there in the first place? What are they trying to set straight?
Yeah, so I mean, for this generation, what they're thinking of is the Dred Scott decision. So that's a decision right before the Civil War in 1857. Harriet and Dred Scott were enslaved people. They were brought onto free soil. And they said, because we're brought onto free soil, we are free. And they brought their claims in court for their freedom. It got all the way to the Supreme Court. And in a decision the opinion written by Chief Justice Roger Brooke Taney, he said, no, Scots, you're wrong. You can't be United States citizens, and you, quote, have no rights which the white man was bound to respect. But the generation here that's writing the 14th Amendment, it's the Republican Party, it's the party of Lincoln. One of their fundamental beliefs is the Supreme Court was wrong in Dred Scott. Dred Scott was the wrong the day it was decided. And what they wanted to do with the 14th Amendment, with especially that citizenship clause that we read, was to say, no, Dred Scott's wrong. African Americans can be citizens. They do have rights. And we're going to write it into the Constitution and guarantee it. Why are we writing it into the Constitution? Well, in part to take that question off the table, because the Reconstruction generation knows eventually the ex-Confederates are going to come back into the national government. And they wanted to make sure that once they came back into government, they couldn't take away those rights and reimpose something like Dred Scott. So that's what we get from the citizenship clause. We see this debated during this period, Kerry, culminating in a key Supreme Court decision, Wong Kim Ark, which is in 1898. So this is 30 years after the ratification of the 14th Amendment. And who's Wong Kim Ark? Well, he's born in 1873 in San Francisco. His parents are Chinese citizens. And what happens is his parents leave the country. He goes to China to visit his parents, and then he comes back, and the United States refuses to let him back in. And so this period, what's important to know about it is there's a lot of animosity, a lot of discrimination against the Chinese who are coming here. And so we see all sorts of restrictive legislation passed by Congress. And so they're saying, no, Wong Kim Ark, you cannot come into this country. You are not a United States citizen. And he challenges this in court. It gets all the way to the Supreme Court. And in a 6-2 decision, it's a really important one. The Supreme Court says, Wong Kim Ark, you're right. Your parents may have been Chinese citizens, but your citizenship is rooted in our soil. The fact that you were born here, it's not passed down from parent to child. Instead, in this case, it's connected to the very soil. And so you are a United States citizen. So it's a reaffirmation of a broad vision of birthright citizenship. I mean, the last thing I'll say, Kerry, is there was a dissent here. And so it's a 6-2 decision. And so in a way, it parallels some of the debates you see today over the status of the children of undocumented immigrants and whether or not they're citizens, which, the majority rule is still what you see in Wong Kim Ark. If you're born here, you're a United States citizen. But the dissenters in arguments that sort of trickle, that sort of flow all the way through to today, say, no, the correct reading of the 14th Amendment is that citizenship passes from that parent to the child. And so if your parents are citizens of another country, then citizenship doesn't attach to you. So just to sort of bring that debate to modern times, but the point is, 1898, the Supreme Court weighed in on the side of a broad vision of birthright citizenship.
And that is such a good point, because when we think of things like birthright citizenship, when we think of things like the right to vote, which you can see in that article in the newspaper from this time period, when we think of things like whose job is it and whose power is it to make decisions, the national government or the state government, and even the meaning of equality, these in that setting, if you asked a bunch of people those questions, they would say they're all modern questions. But we've been debating and discussing and watching the courts try to figure this out as well since the 14th Amendment was adopted to the Constitution. So this is why the 14th is so important and a part of so many modern cases. Now, one thing about Wong Kim Ark's parents, if I remember correctly, his parents just didn't leave because they wanted to go back to China. They were being deported. And he was, I think, 20 years old. And that's why he was able to stay in America. And he went back and forth a couple of times to see his parents because they could no longer stay in the United States.
Yes, I think that's right, Kerry.
Awesome. Just wanted to make sure we understood, there's a lot of animosity going on.
Oh, yeah. It's a huge national issue. You can't understate, or can't overstate how important this issue was to the politics of the time.
Awesome. So next kind of big feature is the protection of equality. And when I think about protection of equality in the 14th Amendment, sometimes that can be so opinionated on what people think it means or what does it look like, and more of a political question, like a should question. But when we want to go back to the Constitution and what is the constitutional question, it leads us smack dab right back to John Bingham. So I know you'll like to talk about Bingham and what he meant by protections of equality and freedom in the 14th Amendment.
Absolutely. So John Bingham, he's in the U.S. House of Representatives from Ohio during Reconstruction. He's the primary author of that language in the 14th Amendment that we just read. The great Justice Hugo Black refers to him as the James Madison of the 14th Amendment, and that's a good way to think about him. He was the primary author of so much of the text that we debate today, but he was also a member of that generation still in government debating the meaning of that text after it's ratified. So he's kind of this amazing central figure in the Reconstruction story that we forget about. And, as to his vision, one thing to remember is, again, that the 14th Amendment was a key part of the politics of that moment. And so Congress passes the 14th Amendment in 1866, sends it to the states for ratification, but that year is an election year. And so you have President Andrew Johnson opposing the 14th Amendment, going on the stump, going on the campaign trail, saying, don't elect people like Bingham, don't elect the Republican Congress, elect my supporters and reject the 14th Amendment. And then you have Bingham on the campaign trail defending the 14th Amendment, saying this is essential to creating the America that we fought for in the Civil War. And he advances a vision. He's at a campaign stop advancing a vision of the 14th Amendment and its commitment to equality. And he says, what we want, we sought a, quote, simple, strong, plain declaration that equal laws and equal and exact justice shall hereafter be secured within every state of the Union, guaranteeing equal protection for any person, no matter whence he comes or how poor, how weak, how simple, no matter how friendless. And you can see here how that resonates with our founding principles all the way back to the Declaration, all the way through there. And Bingham and his generation are trying to write that into the Constitution. And the amazing thing is that for a brief moment, it works. We see an important experiment in multiracial democracy in the South. Right after this period, we have African-American governors, senators, U.S. House of Representatives members, state legislators, all the way down to sheriffs in various localities. And so it works. African-Americans voting in massive numbers, shaping the ratification of the 14th Amendment, 15th Amendment, key Reconstruction laws throughout that period. But of course, it collapses far too quickly because of white violence from groups like the Ku Klux Klan, because of growing indifference from white Northerners, and also because of a Supreme Court that read the Reconstruction amendments quite narrowly. And this brings us to maybe the greatest symbol of this during this period, which is the infamous decision Plessy v. Ferguson. And so this is 1890. Yeah, I'm sorry, Kerry. Yes.
Yeah, no, it's great. I was going to say when we talk about Plessy v. Ferguson, what we're seeing is this kind of rollback of Bingham's ideas and Bingham's vision, but we're also seeing amazing American heroes like Plessy saying, nope, I'm going to go in, I'm going to fight, along with others supporting and doing the legal work, but going in and saying, we're going to fight this and say how this isn't being done in a fair and a true way to the 14th Amendment. So yeah, tell us all about Plessy, and then we'll get into the dissent and all those favorite pieces.
Yeah, no, and it's a great point about Plessy, because we should remember for this whole period, even before the Civil War, we have African Americans advancing their own visions of what citizenship, equality, and freedom means to them. We have African Americans meeting in convention and sending messages to Congress saying this is what we need for a second American founding. And so Homer Plessy here is very much in that line. And this often takes courage, because they're often doing it in the face of violence, in the face of laws that run up against them. I mean, what is Plessy responding to here? It's Jim Crow segregation. It's a law passed by the state of Louisiana that's requiring separate cars on railways for African Americans and white passengers. And Plessy himself is an African American in Louisiana. He's part of a committee of citizens who want this law struck down as unconstitutional. And so he agrees to be part of a test case. I mean, the argument is very simple on Plessy's side. It's read the Constitution. Think about what we've just written into the Constitution. Read the Equal Protection Clause. A law like this treats African Americans unequally. It's a badge of inferiority, and it has to be struck down as unconstitutional. And so Plessy brings this in the courts. It ends up before the Supreme Court. And the Supreme Court, in a 7-1 decision, says, Homer Plessy, you're wrong. The state of Louisiana is right. This Jim Crow law is constitutional. It's allowed. Separate but equal is fine. And so this is an opinion by Justice Henry Billings Brown. And so what he says here is effectively that, look at the law. The law on its face doesn't say any negative things about African Americans. This law is within the traditional, very broad powers of the states to pass laws in the interests of the health, safety, and welfare of their residence. And then finally, if African Americans read this law as something that makes them feel inferior, that's their problem. There's nothing in the law itself that says it. And so in the end, this is constitutional. But remember, it's 7-1. There's one dissenter. And so we have one powerful voice that says, no, 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 this is ridiculous. This is the voice here is Justice John Marshall Harlan. He's an unlikely voice in many ways. He was a former slaveholder from Kentucky. He opposed Lincoln in 1860, opposed Lincoln in 1864, opposed the Emancipation Proclamation, opposed the Reconstruction Amendments, but he himself was changed by the history unfolding in front of him. He was changed by the white violence that he saw against African Americans in the South. He was changed by the explosion of Jim Crow laws and laws discriminating against African Americans, the Black Codes before that. And in the end, he becomes the strongest voice on the court for a broad reading of the Reconstruction Amendment. And in many ways, Plessy v. Ferguson, his dissent here, Kerry, is the fullest example of that. I'll sort of pause right here before digging into what he has to say. I don't know if there's any questions or any clarifications.
I think there is. I think that's so important because we think about like the fight for Plessy, but so often when we look at American history, the question is always like, did they know? Did they know back then what choices they were making and how much of a repercussion it would have? That was like my biggest question around the 13th Amendment and the loophole about incarceration was like, did they know by putting it in there that this would be the outcome? And maybe not to the extent, but you can read the writings and hear, yeah, they did. Sumner was like, don't put it in there. But this is what I love about Harlan's dissent. He is not waiting for history to tell them what's going to happen. He is calling them on it right away and say, don't kid me. Don't kid yourselves. You are doing this in a way, you are doing this because of race. You are doing this wrong. So read the dissent. But as we think about it, we have people at this time like Plessy, like so many others that are fighting for it and calling out, what they're doing wrong and what it really is.
Yeah, and I mean, it's a reminder also in the importance of dissents at the Supreme Court. Sometimes the dissents keep certain visions of the Constitution alive and allow us to reclaim them later, which is precisely what we'll talk about, in a little bit. But here Harlan really says to Justice Brown and his colleagues, "Are you crazy? How could you not see what this law is achieving? It's not there to keep white passengers out of African American cars. It's meant to keep African Americans from going into white passenger cars. It's about white passengers being uncomfortable with African Americans. Of course, this makes this brands African Americans as an inferior class here in the United States." And here's the powerful language from Harlan's dissent. So famous, so important, worth reading a little bit of it. Here's Harlan. "In the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by the tribunal in the Dred Scott case." Those are strong words. Justice Brown, who wrote the majority opinion, he's a Republican, the part of the Republican Party that said Dred Scott was wrong. Harlan saying, you are not being faithful to your own constitutional heritage, Justice Brown.
So when we think about this, when we think about the dissent saying almost like a truth that we need to follow, but we're not following it through the courts or through our laws, and we think about all the people in the years from 1896 to 1954, we also think about, all these families and their children that are putting their lives on the line. I keep trying to think about, it's a 1930s case in Louisiana about a man wanting to go to the university. He wins the case in 1930s and then he disappears. They say that he is afraid for what's going to happen to his family. That's why he disappears. But in reality, he was murdered and his body was never found. So we are talking about extreme violence to stop this change. And then we get to the Brown case. And I know this is a bunch of cases that lead up to this. So many, many people fighting for a long period of time to make real change.
Yeah, so Brown we're fast forwarding to 1954, but you're right, Kerry. Like most constitutional change, big change, it takes years. It takes the actions of people in politics, people on the ground, and people often inside the courts. And so just looking at the court story here, we're seeing a strategy that was put forth by the NAACP, its leader, Charles Hamilton Houston, his protege, Thurgood Marshall, building up case upon case, chipping away at Jim Crow segregation in the South, and leading up to Brown saying that, chipping away at Jim Crow in the context of colleges, in law schools, all leading up to Brown versus Board of Education, which in many ways was the big one. We're talking about public schools, something that's going to touch every community in America. And so who is Linda Brown? Well, she's a third grader. She's a third grader in Kansas. All she wants to do, she wants to go to the school that's closer to her house. It's 7 blocks from her house. She wants to go there to the Sumner School. Why is she excluded? Why is she told she has to walk 6 blocks and then take a bus across town? Because she's an African American, and because only whites are permitted in that Sumner School. And so she says, effectively, that's not fair. That's unconstitutional. It violates the Equal Protection Clause. And Brown versus Board of Education combines cases from around the country, students and families effectively saying the same thing, everywhere from South Carolina to Kansas to Virginia to Delaware to Washington, D.C. And what this case really presents is, on the one hand, you have Plessy v. Ferguson on the books. The court decided Plessy, what would that be? 50, 60 years ago at this point in time. It's established precedent saying separate but equal is constitutional. And so they have that precedent on one side of the court. On the other side, they have Linda Brown's argument, which is that in the end, the Constitution has a promise of equal protection of the laws written into it. Segregation runs up against that, and the court has to resolve that conflict. And what the Supreme Court does in a unanimous decision authored by Chief Justice Earl Warren is it says, Linda Brown is right. Plessy v. Ferguson was wrong the day it was decided. Separate is inherently unequal. And so even if these facilities were equal, which of course they never historically were, but even suppose that these facilities were equal, that would still be unconstitutional, because by separating out African-American students and white students, you are branding African-Americans as second-class citizens, and you are branding within these children a feeling of inferiority. And as Chief Justice Warren's, as part of his opinion, he writes it in simple language. It's a short opinion. He gets every justice, despite some of them having some reservations, to sign on to this opinion. It's printed in newspapers throughout the United States. It's important to Warren that he writes in simple language that everyone can understand, a short opinion everyone can read in their newspapers. And in part of that opinion, too, there's this interesting part where he relies on some sociological research that was done as to African-American children, which was sort of a strong example, he thought, of proving that these things like segregation in the schools are making African-American children feel inferior. Because what they did was they handed, in the studies, they handed the children a doll, an African-American doll and a white doll, and they saw that even the African-American children preferred the white doll. And this was seen as sort of a powerful statement of this feeling of inferiority that's being instilled in African-American children.
And so as we think about, and the doll test is, we'll send it out to everybody as well. And it's under the 2 psychologists, the Clarks. It's unbelievably powerful. And one of our teachers pointed out in the last class that they actually have the dolls now at the African-American Museum in DC, which I think I did miss that with the last time I was there, but an amazing museum that is just unbelievable experience. So when we think about, fighting for equality and fighting for freedom, it expands past the schools, but it expands to your own choices. You have the right to choose how you live, and really simply, like, who you love. And so that brings us to the Loving case. I absolutely love that their name is Loving too. I feel like the universe set this up perfectly. But can you talk to us about marriage equality?
Sure. So Brown's in 1954. In 1964, Congress passes the Civil Rights Act of 1964. In those years in between Brown and Loving, we see the Supreme Court expand and apply Brown to many, many other situations, continuing to strike down against Jim Crow laws throughout the South. And in Loving v. Virginia, they take on a really important issue, which was the issue of interracial marriage. And so this is Mildred Loving, Richard Loving, they're residents of Virginia. They want to be married, but there's a law on the books in Virginia that says interracial marriage is illegal. And so these sorts of laws extend back all the way into the 1800s. These are longstanding laws. There's still 15 states at this point in time that have these laws on the books. And so what they do is they go to Washington, D.C., get married, come back into Virginia. In the end, Virginia prosecutes them. They're found guilty, and they challenge this law as unconstitutional. And so they come before this case works its way up to the Supreme Court, and the Supreme Court says, Lovings, you're right. Virginia's law banning interracial marriage, it's unconstitutional. It's unconstitutional both because of the 14th Amendment's commitment to equality. I think Chief Justice Warren's words here is that, when you discriminate on the basis of race, it's odious, and the state needs a really good justification for doing it. The other, though, is that they say that it also violates the 14th Amendment's commitment to freedom, that under the 14th Amendment, it protects fundamental rights like the freedom to marry. And in this particular case, this is standing in the way of two people who love one another and want to get married, and the state does not have a good justification for saying that they can't. And so with Loving v. Virginia, we see the Supreme Court strike down Virginia's ban on interracial marriage.
So this really quickly jumps us to another marriage case, and I always had a little bit of trouble of understanding why Loving v. Virginia just didn't apply here. So, and I know this comes out in the ruling in both the opinion and dissent, but can you kind of break us down what are the similarities and what are the differences between Loving v. Virginia and Obergefell v. Hodge? Because they're both marriage cases. And I guess my brain was just kind of like organizing it under the government giving a marriage license. And what are the rulings around that?
Yeah, sure. So Obergefell v. Hodges, we're going to fast forward to 2015. And so this is the constitutional challenge to state bans on same-sex marriage. And so in many ways, if you read unlike Loving v. Virginia, which was unanimous, Obergefell v. Hodges was a closely decided case. It was 5-4. The majority opinion written by Justice Anthony Kennedy struck down bans on same-sex marriage throughout the country, said that they violated the Constitution. And in a lot of ways, if you read the opinions in the case, you're right, Kerry, it becomes really a battle in some ways over the meaning and how to read Loving and how broadly its principles sweep. And just to sort of summarize the arguments on each side, if you read Justice Kennedy's opinion in the case, effectively what he says is this case is precisely like Loving v. Virginia, and the same sort of principles that apply there of freedom and equality apply in this situation. That had to do with race. This has to do with sexual orientation, and he saw that as a pretty tight analogy, and therefore expanded Loving v. Virginia to apply in the case of same-sex marriage. On the other side, what the dissent had to say, but also, well, let's start. What did the states argue in this case? Well, they argued that one, the issue of marriage and the issuing of marriage licenses, it's within the traditional powers of the state. Two, that marriage, the traditional definition of marriage between a man and a woman, is something that's been with us for centuries. It's as a matter of tradition and custom. It is well established. And three, sort of because of that, we have a state interest in preserving that traditional definition. And so that's what the states end up arguing. And just a quick gloss on the dissent, Kerry. So there's 4 dissenters. Each of those justices write their own opinions. So if you want to see what the dissents have to say, you could read each of the justices, see how their opinions differ. I think the one that gets the most attention is the dissent by Chief Justice Roberts. And what he effectively argues is, one, the states are right. This is a traditional area of, state power. 2, they're right that the traditional definition of marriage has lasted for a long period of time. At the same time, the Obergefell challengers are right that this is a topic of extensive political and constitutional debate right now. Public opinion is shifting. It's shifting in favor of those in support of same-sex marriage. And what Roberts argues is that, the Constitution is silent on this issue. And as a result, this issue should be left to the the elected branches to decide one way or another. Effectively, it's not a constitutional question, it's a policy question. And so as a result of that, we should defer to what the elected branches are doing and allow the constitutional and political debate to go on. So that's sort of the dividing line between the two.
And I always think that's so important on these cases, because we do have a tendency to go to the should question. Should we do this? Should we do that? And they're the policy questions. And Roberts is even saying, like, we're doing it here. But we really look at what are the constitutional questions. So I find this case fascinating in so many ways. In storytelling, it's a fascinating group of cases, but also that there's 4 dissents, and reading them, there sometimes is alignment and there's sometimes no alignment. So a really good one to dive deep into, just in case you don't have your weekend reading ready yet. We got you covered.
Exactly.
This is fantastic. What a great way to kind of look at the 14th Amendment and understand kind of what is the original intent of the writing of it, but then how it's been defined by the courts and the actions of the people to bring it to the courts over time, and that kind of movement back and forth, back and forth. And we didn't really talk about some of the rollbacks on that, like the slaughterhouse cases, but they're in there as well. We looked at Plessy as well, but they're in other areas, not just in the areas of equality. But thank you so much for a great class. Everybody, we're going to wrap up real quick, but if you have any questions, we will hold to the end for questions as well. So let me just end the recording.